Okay, we're ready to go. Good afternoon, everyone, and welcome to the sixth and final session of our webinar series on the new Title IX regulations. I'm Tom Mercurio at the University of Vermont, and for myself and the whole continuing education team here at UVM, thank you for tuning in. We're pleased to connect you remotely and to be able to keep this conversation going about the new legal requirements that will take effect at the end of this week. Today's presentation is about the training requirements contained within the new Title IX regulations. We look forward to an engaging discussion. Remember that you can post your questions in the chat space for our expert panelists to address. Now I'd like to introduce and welcome our panelists. First, Marjorie Fisher, Associate Vice President and Title IX Coordinator at Columbia University. Marjorie, thanks so much for joining us. And Jeff Nolan, Senior Counsel at Holland & Knight. Jeff, great to have you back. With that, I'll turn it over to Jeff and Marjorie. I understand that you'll be muting on and off, so we'll make sure we try and signal you if I have any trouble hearing you. Let's get started.
Great discussion over the summer regarding these issues, and as difficult as it's been to work so hard since May to get to this point, a couple days out, at least we know we've done a lot. We know our policies well, and those of you who are here now obviously are at a place where you've advanced it to a point where you can be thinking a little bit forward. The policy is in a place where you'll be able to post it on Friday, and you're thinking about what do we do next. And one of the things you think you do need to do next is you need to train your folks at the very minimum as required by the regs. Now, you don't have to have that done by the 14th, but there are things that need to be trained on before those individuals work on a case. So that's really what we're going to focus on. But we're also going to talk some about longer term issues still, things that are going to involve training and discussion awareness raising for your students, for your employees, to the extent that they're still required to report concerns that are reported to them and those sorts of things. But we'll start off talking about what the regulations themselves require. Revisage is there. You've heard from me before, so there's my bio. I'm not going to repeat it. Margie, we had probably the first of these conversations, you and I, Elizabeth Conklin from UConn, but if you wouldn't mind introducing yourself a bit, that would be terrific.
And the Title IX coordinator for 4 years. Before that, I worked at a consulting company where I traveled around the country and did Title IX investigations. Called T&M Protection in New York City, which was a group of ex-sex crimes prosecutors that worked together, when things were really happening in this space for the first time, and people were getting much more involved. But before that, I spent 30 years as a New York City sex crimes prosecutor. I was the chief of the Special Victims Bureau in the Queens DA's office for 23 years, and before that, I tried rape and homicide cases in Brooklyn in the 80s, back then, for 8 years. So that's who I am. And in my job now, I oversee the Title IX cases, patterns, training, and so on, and have been working very diligently with wonderful people like Jeff and others to get our policy in ship shape by Friday.
Here's some of that. I'm not going to read slides at you. You'll have them as a resource. There's definitely a lot more slide content here that we're going to talk about. We really do hope to have a chat-based discussion with you, answer your questions. But one of the things that we know is something to celebrate, a few things you can, is that those of us who've worked hard on trauma-informed investigation issues and training around those issues did get some validation from the preamble. So this is a resource I've cited a couple times, a NACU note I wrote in February of 2018 that the National Association of College and University Attorneys published back then. And I updated it in the summer of 2019 to reflect that the proposed regulations were requiring that we not have sex stereotypes and that we not have evidence of gender bias in our training. And so it's part of emphasizing that trauma-informed approaches can be absolutely fair to all parties so long as they're applied in a way that is um, really demonstrably so and very thoughtfully crafted to make sure that we are being fair across the board. That's something that some advocates for respondents that, for example, had criticized in the regulation comment process, and ultimately the Department of Education's response was, well, we can absolutely use trauma-informed approaches so long as we do it right, and it cited these resources. So for those of you who've been working on those, there's some validation there to continue to be thoughtful of that. As we plan our training, we can continue to incorporate those pieces in there, which is terrific. And we'll talk about that more later on in the program. So you saw it, the first slide was we have to avoid sex stereotypes. Well, how do we do that exactly? Department of Education did not lay out in the preamble exactly what that means. That language is in the regulation. What does it mean to avoid sex stereotypes one way or another? And so they left it quite open, which frankly is fine with me because I really don't want to have that be scripted for us, because I think we can tailor that to our community where we feel our community is at, and then appropriately work from there. So focusing on conduct and not anyone's gender seems to me the place to start. We really are focused on um, domestic violence, dating violence, sexual assault, stalking, and serious, significant instances of sexual harassment. We're not focused on the gender of anyone. We're not in this work to find men responsible because they're men, or to support women because they're women. We're here to be respectful and appropriate in working with both parties through a process that's going to be very difficult for everyone, recognizing that anyone can be a perpetrator or a victim of sexual assault, regardless of their gender identity or their sexual orientation or their sex. So one of the things that that's worth doing is recognizing that while the majority of the cases that come forward and are actually reported to us on campus focus on the concerns of cisgender heterosexual women who say they were sexually assaulted by cisgender heterosexual men, and that is obviously, being the highest percentage of what comes forward, a extremely important and problematic facet of our society, as it has been for millennia, frankly. Um, that's not all that's out there. And so one of the ways to make sure that folks understand when we're doing training that this is not about gender, it's about conduct, misconduct as proven through our policies, if that's what the evidence shows, is to be less gender focused in our presentations. It's one of the things I've read about in the paper the Department of Ed cited, is that there are data out there that talk about the experiences of men who've been sexually assaulted by other men, of women who've been sexually assaulted by women, of men who've been sexually assaulted by women. Those data exist, and we need to work just a little bit harder in identifying additional resources if we're going to be talking about prevalence and statistics. And that also goes with dating violence, domestic violence, and stalking. The data are there. If we want to make our presentations more balanced, to emphasize that it's about conduct, not gender, we have the ability to do that. So I wanted to cite to you a few resources that you could look to, but there obviously are many others, but these are just examples. The CDC, an enormous study, 16,000 survey respondents, presumably the CDC knows how to do a survey, and came up with some rather surprising findings to me, at least, because I don't work as an advocate and wouldn't have met with people reporting their experiences confidentially. They were able to estimate from survey data, extrapolating across the US population, that in the year before the data, before the report was published, the year before the survey was published, and the link is here, they estimated that 1.27 million women were raped, but also that 1.267 million men were made to penetrate. And that's their data, their quotation. And it's something that's surprising if we haven't been involved in the field, but it shows us again that sexual assault is not only an experience of one gender versus another in a binary way. These data were pulled out in a sexual victimization of men article It's here. The citation for it is here. It's a quick read. I commend it to you. It talks about not just the CDC data and the fact that the CDC findings on the front page didn't really focus on the surprising statistic I had on the previous slide, but also noting that there are reasons why men don't report at the rates that women do, even though there are still instances where men are sexually assaulted by men and by women. Much smaller survey, but in this one only 300 folks. But they noted that in people who had men who had experiences of um, sexual victimization since they were 16, who were then college age at the time of the survey, almost half reported that the incidents involved female perpetrators. So again, this is not about gender or sex, it's about conduct. And that's something that we can bring out and emphasize these resources in our presentations to make sure that people understand that that is our institutional orientation. It's not that we are focused on one gender is someone we support and another gender being binary about it as a group that we want to hold accountable for something. Instead, we hold people accountable if our process demonstrates they've engaged in misconduct and not before or not until. Another a resource that the CDC put out from the same data set in 2013, pulling from the reported experiences of LGBTQ respondents in the survey, showed these key findings. I won't read them at you, but obviously these are things that you can illustrate and emphasize in your programs to demonstrate to people that there are a range of experiences that we need to be cognizant of. So I wanted to ask Margie what your thoughts were on these issues, how you could see incorporating these kinds of themes into work that you or others in your field are doing around training related issues in this space.
That these are incredible statistics, really wonderful to have as you go down the road as an investigator or a hearing panel member or chair. And I think, and just as a student at a university, and I think that it is really important to keep them in mind as we train, in particular, our investigators. I have done dozens and dozens of trainings of investigators at Columbia and other schools, but I've also trained a lot of detectives over the years because I was a special victims prosecutor. And one thing that I talk to them about is if you have a case involving an allegation of a man who's been sexually assaulted by another man, for example, the first question to them is not about, their sexual preference, their choice, anything like that. The question is what happened? And one shouldn't, jump to a conclusion that this was, some sort of, something that happened as a result of something that started consensually. If the description is a credible description of, an act of control and violence and power, just find out what happened. And don't start the conversation asking about somebody's sex life, anything like that, because that is just wrong. And it will put people off. And so I think seeing these statistics, particularly on the slide from the CDC National Intimate Partner and Sexual Violence Survey 2013, shows that the rates of violence among lesbian women and gay men are equal or higher to those of heterosexuals. So the assumption, that this was just, a sexual interaction that went poorly is wrong and outrageous. And so the questioning should begin at a place of tell me about the incident and not at a place with, tell me about your sexual preferences. So that's, this kind of information has really guided me in my own investigations and my own training when I'm dealing with cases like this.
Yeah. Thanks, Margie. Absolutely. Absolutely. There's a question about training for decision makers. An echo going, but I'm sure this will help us with that. The question is around training outside decision makers, because lots of times schools are going to hire outside contractors to do that work. And um, how do we see that these folks are trained, and how do we obtain their training to demonstrate that they've been trained? And actually, just in the way that I framed that question, um, how can we obtain the training for web posting? So when we think literally about what the regs require, they say you have to do training, and the folks that are going to serve in these roles have to have training. And when you do training after August 14th, 2020, that training's got to be posted. But one thing I want to emphasize is that um, there are a lot of things that are very mandatory in these regulations, but where they are literal, we can typically take them literally, unless you've got some preamble language specifically that says to the contrary. You don't have to post old training materials. You don't have to be gathering up various things that people have attended over the years and sticking a bunch of PowerPoints on your web page to demonstrate that people have been trained in the past. Okay, you have to know that you're going to do the orientation to the new regulations as required. You're going to topic areas, um, and when you do that, I've already done some of that already for schools. Technically, we've covered all of the areas, and I've been doing it for weeks now for some schools that are really ahead of it. Others may need to come, but you don't technically have to post the old stuff. They probably will to demonstrate, but it's not about demonstrating the old qualifications for the old trainings. There may be folks who have a lot of experience who indeed do these trainings themselves, who don't have an extensive um, current training uh, group of postings they can have for you. But to the extent that people do things, I think their biggest challenge is they're going to have to make sure if they're going to go to commercial trainings, and there's certainly, there's a couple of different ways to do training. I mean, one is hire somebody to talk to your institution. I was going to say go to your institution, but we never do that anymore. I used to do a lot of that. Right now it's all virtual. Hopefully that will change soon. But what we do is you can either do custom training for a campus and have a very direct conversation about their practices, their policies, their scope of educational activities. In a lot of ways, that is ideally suited to the regs because that's what you're supposed to be doing according to what the regs say. But there's a lot of folks that are providing training. X number of dollars, sign up from anywhere in the country, and we'll train you for X number of hours, and you'll get the basics, but you won't get the focus on the institution's specific rules. You'll get Title IX sexual harassment generally because it's generic, but you won't get the specific stuff. I would say your outside folks are going to have a fairly easy time getting the generic stuff. It's available everywhere. The specific stuff about your campus, you may have to invite them in to participate when you train your internal people. If you have internal, obviously your Title IX coordinator has to be internal employee, but everyone else can be a vendor, can be a contractor, investigators, decision makers, etc. Probably your sanctioning people are internal. What I've seen clients doing a lot of is inviting their external folks that they intend to use into those trainings. And I've done a bunch of them, and that's just what they've done. And we just send out the Zoom to them, and they attend. Margie, I don't know what your thoughts are on that.
We've done a training recently. Jeff participated in it actually about the investigations under the new regs, and we had another presenter who did work in the afternoon on hearings. And anybody who we thought might be an investigator, for example, an outside investigator, although we have 4 at Columbia, our numbers were down. So we invited people who we expected could possibly do an investigation at Columbia to watch, so that we could have we knew that they had watched and learned all of the different things that they're required to know. So if they do an investigation for us after the 14th of August, we have confidence that they understand the definition of sexual harassment, the scope of our educational program or activity, and how to conduct an investigation, and grievance procedure, in a way that's fair, and not based upon what sex someone is, as Jeff mentioned earlier. And so I do think that's a very good idea. I also would recommend that if you have somebody come in to do training, you make sure that you spend a fair amount of time talking to them about how things are done on your campus, provide them with your policy, talk to them about the strengths, the weaknesses, what's happening there, so that they can speak to your internal staff who deals with these issues every day from a place of confidence and knowledge. Because having someone coming in and doing a generic training based upon just the new regs doesn't really help. And if you have people of a certain level of skill, it's not going to be informative to them. So I think spending the time preparing the person who's coming in and making sure that anyone who's going to play a role, like on a panel, on an appellate panel, as an investigator, is sitting through those trainings is critically important. Even our case managers are there, the people that greet the students and talk to them about accommodations. They need to know exactly what the process is going to look like and what the investigation is going to be like. They need to have that picture so that they can say to students at the front end, look, this is what you can expect.
Thanks, Margie. Same point again. This was a particular judge making a comment in a case where a respondent, a student, was excluded from school or suspended, found responsible for sexual assault, and his argument was one of the panel members volunteers in their spare time for a rape crisis center. So how could they possibly be objective in my case? There they are out in the community working for an organization that supports victims of sexual assault. And the court said, as you can see here, there's not exactly a constituency in favor of sexual assault. It's difficult to imagine a member of a hearing committee not firmly against it, but that doesn't mean that they can't judge the facts of a particular case fairly. So it's word to the wise, good information. I'm not going to talk about this in detail. How do we have a conversation about harassment definitions? We've got to add examples. So I was on one the other day. It was a 2-day program, but most of the background was covered in a day. We had to use examples for how this really technical language was going to be applied in our investigation and in our hearings, because we need people to understand it. The regulations are saying you've got to have some training on the definitions. There are new definitions and what they mean, but you can't just read the definitions to them. You absolutely have to do that. And then often you're going to have, most of the policies I'm working with, schools are saying, we're going to prohibit sexual harassment as the new regulations require. We're also going to prohibit lots of other things that are maybe outside the program or activity of the school, or that are a different level, maybe a lower level sexual harassment or sexual exploitation around distribution of images of sexual activity or nudity that were without consent, but that may not rise to the new sexual harassment threshold. You got to talk about all that stuff so that the people doing your investigations and your hearings know what they're going to be faced with when they get into an actual case and feel really comfortable with it. But to me, examples are the only way to go. Margie, you want to add to that at all?
I was just going to say that I think that the examples are key, and even if it has to be, half of your presentation, it's going to lodge in people's heads much more than just the 2,033 pages of the preamble. I just also wanted to just tack back for a minute with the example of conflict and bias. I think that since this is now a highlighted grounds for appeal for just about everybody who works in the process, and we all know here about the numbers of people who work in the process who are former defense attorneys. Many of them are former sex crimes prosecutors, and whether that is going to be there's the internet, you can find out about anybody's past. How many times are students going to say, hey, my Title IX coordinator can't preside fairly. She can't oversee these cases fairly. She worked in this field as a defense attorney. She could never understand what a victim is going through. Or she was a sex crimes prosecutor for 30 years. How can she possibly be fair to me as a respondent? And so I think that we have to look for cases with language like that, Jeff. But I'd be really interested in hearing from you about how schools are going to deal with that, because it happens that the people that are drawn to this work and want to make a difference in this space are oftentimes people with backgrounds that are consistent with being effective at handling these complex cases, talking to people who are at a very difficult time in their lives, and it makes sense, but I think it's going to be an issue.
It will be raised. I have no doubt about that. The preamble is explicit that for OCR's part, they are not going to view those sort of categorical arguments as having weight. There's going to have to be something more than just the professional background of the person. That is not going to disqualify people from OCR's. They said there's a slide in here that says that eventually we can skip over it when we do that. We don't run personnel issues on college campuses. We think you should affect a fair process, and you should have a fair process, but we're not going to tell you who to hire and who not to, who the sexual, who can be in there as a sexual assault support person, or who can be there as a Title IX coordinator. That's not for us to say at the department. They have lots of other things that they say very strongly, but on that point they did not. And their basic point is, people will have to be fair, and they will have to be demonstrably fair. And they chalk some of it up to training. I don't think training in a conversation in a day is going to change someone's worldview built over 30 years. If they have decided that, as a criminal defense lawyer, that they have some impression that sexual assault is more falsely reported than other things, and part of their world is to make sure that doesn't happen on the campus, well, that's a problem, and that's a hardwired issue that we have to be thoughtful of. Same thing as if they were acting like a prosecutor, the Title IX coordinator. But my view is these are folks that are highly sophisticated at dealing with very difficult issues, who have been working in the justice system for a long time, working on opposite sides of what in the criminal justice system is adversarial by nature. But it doesn't mean that as people they believe everyone that comes forward for a sexual assault should be believed, or that everyone who's engaged in it actually did. I've certainly not seen that in my experience. So, these arguments are going to come along. They could have come along before, no question about it. And we saw it back in the 2005 case that I knew. But, categorically, it's not going to be an issue. I think we do have to be very thoughtful about how we present. So if someone is a Title IX coordinator, an investigator, a decision maker, an appellate officer, a sanctioning officer, you have to be very thoughtful of your public presence around these issues. What you retweet, what you say, the posters on your wall, all of that. You've got to be very thoughtful about how will that present to someone who is in a complainant or a respondent role in one of these cases. And if there's advocacy going in either direction, to me, take it down, because I know you don't mean it. You're in this work to do justice on your campuses, but don't put yourself in a position where you end up having to answer for that, and then you can't be involved in a case and do what you can. There's a good question here about how do we bring in external trainers given budget restrictions. I have some thoughts on it, but I want to pose it to Margie first because she's on the inside.
I have found, although, it's hard to be on Zoom all day long, we used to do small trainings. We're a well-resourced institution, but, at the end of the day, there are a lot of people in New York City and New York State that, could not hire people to come in and, hear people like Jeff and others talk about these things in a very thoughtful and expansive way. So last year, we decided to just invite a whole bunch of people, people from community colleges, people from CUNY, people who absolutely could not have done this on their own. And it was fantastic. It was like a consortium. And I think, instead of having 20, we had 120. And managed to get CLE credit. There was a great conversation and tons of questions back and forth about different kinds of institutions. People made connections and kept in touch. And now you can do it even easier. We had to do our annual investigator training. We did it on Zoom. We invited a ton of people. They were all there, and people were thrilled to have the opportunity. And I would say every couple of minutes somebody asked a question and someone else said, I'm so glad that you asked that. That's terrific. So I have gotten only, positive feedback from expanding the group. We charged very little, and we were able to, you know, bring great people. So I would highly recommend sort of an idea of doing this as a consortium in the training space, because I think it brings a great deal of life into the training and brings, very interesting points of view, and it gives people an opportunity that might otherwise not be able to do it. And now people have to be trained. They're going to come. The SUNY Student Conduct Institute is a good place, it's not too expensive and has tons of online trainings that people all over the country are using. So I do think there are options if you get together with your, schools that are close by who need, the opportunity. And for very little money, you can invite people to be part of this, effort that they need to do anyway, and do it even more often.
Yeah, absolutely. I mean, I'm still getting questions and emails and going back and forth with folks who were on the training that Columbia was gracious enough to pay me and others to do. Um, and it's just great to have the opportunity to connect with folks at different places that I might not have had the opportunity. You know, our expectations about in person have obviously changed so dramatically. And while we do our best to be active for you, is not the same thing as being in person. Nonetheless, the economies of it are quite astonishing, because typically with that kind of a thing, you would have to get a consortium together. Whenever I'm an example, there's hundreds and dozens of people that do this work. We got to be paid to get on a plane, to fly across the country, to do the training. I love being there in person. It's terrific. I flew 50,000 miles last year. This year I've flown none. And we've done a lot more connecting through Zoom. It's not the same thing, but as far as the ability to be very cost effective about it, it's amazingly cost effective, because if you get 5 or 6 institutions or 3 or 4 and they pull together, and it's the vendor says, I mean, people have different models, and some people charge you by how many people show up, which could end up being expensive. But if it's by the hour, is how I do it, and some others too, the more people show up, the cheaper it is. If you have various schools involved, then it's cheaper still. So that's one way to think about it. And I think mostly it is um, working with others, as Margie says, working with consortia, whether formal or informal, tends to be a good thing. Um, oh, this is a great question. So, what if a Title IX coordinator is tasked with sexual violence prevention programming on campus and working with external rape crisis orgs? Will that be seen as a conflict? So, we had a conversation, this informal, but it's the second year of its conference, group called LEAP, LEAP, Leadership Education something and prevention, that was started at with a meeting at Norwich University in Vermont last spring, and then we did a series this spring, and the second to last one we did was around conflicts, but that training can sometimes create. And we looked to the Title IX coordinator, particularly on a smaller campus who doesn't have another trainer, to be doing prevention type work. Um, and then we also looked at them to be involved, and I'll change the hypothetical a little bit, in the process. Um, I think that the prevention work is, again, the focus is we are against sexual assault. We are for consent. We are for circumstances where people have their wishes respected and feel appropriately valued in the interactions that they have. That's part of the prevention work that you do. I mean, you're going to have to be thoughtful of the way you do prevention and not have it be focused in a gendered way or focused in a way that if it were brought up in the context of questioning your um, ability to be objective in a matter where you've got to be neutral would be a problem. So I think that's something to think about. The working with external rape crisis orgs, to me, how are you working with them? I mean, if you're their lead spokesperson and you're speaking for victims of sexual violence who've come forward and that's part of what you do, that's going to sound very different to respondents who come to your office if you're very vocal and obvious on social media, for example. In those venues, it's going to be a lot more difficult and you're going to have to deal with those issues. On the other hand, if they are folks who support some of the people who come to your office, because that's what they do, and then you have other folks who support respondents because they may have personal challenges around the whole process and the counseling center or respondent support units within an institution or people that do, then you're working with them and that's fine. Margie, what do you think?
I think you're right. I do a lot of orientation trainings, and I really try and stick very close to the policy, what it says, what the prohibited behaviors are, what does an investigation look like, where do you go if you need support. And I explain to them that, here's how you get an advisor and here's what a hearing panel looks like. And yes, you can access the criminal justice system at the same time. I don't really, we have a separate rape crisis center on campus that talks more about, the wellness and sexual respect and a little bit more about consent other than what the affirmative consent definition is, which, I cover. I hew very close to the policy, and that is how I feel like, it would be hard to make an allegation that I was biased or conflicted out because I do these. We have a small number of people that, can actually go out there and educate people on that. And our state law requires us to do it. So I think that you have to be a little bit careful. I do work with the Rape Crisis Center on campus, but I'm really going in there, for example, to explain the new regs. I'm not going in there, to assist, complainants who are going through the investigative system. I'm certainly available to answer questions for them, but I'm not providing ongoing support for them.
Absolutely. Thanks, Margie. Okay. So I'm not going to spend time on this. We have to talk about our university's scope of education program or activity. It's one of the reg requirements. This is one of those things where if you're using commercial training that's not tailored to your campus, you've got to build this into the program so that people understand what are some examples of what is within your program and what are without the program, outside the program. It's a technical distinction because most campuses, again, are continuing to prohibit different types of sexual harassment and assault and so on across the board, whether it's just by Title IX or by your other policies or not. But it's something the department wanted training on. So again, if you're going with a commercial vendor who's not focused on your campus, you're going to have to build this in, demonstrate that you did. Okay. So some language here from the regs. I don't want to spend too much time on it, but the basic of it is this. When they talk about avoiding prejudgment, they want to they want to avoid prejudgment of the facts, and that necessitates a broad prohibition on sex stereotypes. You don't want presentations that focus on this is what men do. This is what men who are predators do. This is what women who are survivors do. This is how your typical survivor acts, and that can cut in a lot of different directions. Old school notions of rape myths and victim blaming can be stereotypes of a certain nature. If someone acts in a certain way, then it must have been consensual, despite what they're saying now. We've moved well beyond those things in some settings, at least, hopefully. Then we find other stereotypes that, well, of course, it couldn't have been in that direction, and the person must be believed if they say this. Well, that's not our role to believe people first. That's not something that we can do in this neutral space of investigating and resolving these cases. We've got to go with facts. We don't prejudge the facts based on any direction or another. We're not advocates. And even if we get down to the more granular level of statements that can be made about, victims of sexual assault often behave in certain ways, some of which are stereotypical. There's cases out there that have looked at this issue closely, and people have said, well, I didn't look at that evidence because a rape crisis advocate who presented to us said that counterintuitive behavior of sending a text message indicating that the sexual contact the night before was consensual is actually consistent with what victims of sexual assault do because of all of these reasons. That may be true and it may not be true in a particular case, but what we need to do as investigators and adjudicators is we need to ask questions about that. We could do it in a trauma-informed way. We could do it in a way that's fair and appropriate and does not sound like victim blaming, because it's not. But we have to be fair and draw all of that out. So we can make all of those points, but what it boils down to is we got to go with the fact. That's pointed out here, and while I certainly don't agree with a lot of the things that are in the preamble, this to me makes good sense. RG, what do you
One thing I've learned from you and from other training that I've experienced, trauma-informed interviewing training, is that, there are many things that can happen during and after a sexual assault that can be consistent with or not consistent with a sexual assault. And so what I've learned is, if you have a damning text message from a survivor of sexual assault, um, you know, you can't stop there and say, well, it obviously didn't happen. You have to give them the opportunity to explain, and that might be, here's this text, we have it. Can you tell me more about that? What is it that what were you thinking before you sent it? What did you think after you sent it? Did you get a response? What do you think? What were you thinking when you did? Tell me more about what was going on with you. And it could just be, and I've heard this a million times. It happened 2 days after I got to college. He's part of my friend group. He was so popular. I was terrified that I'd lose everybody I met. This is the first time I've ever had friends. And so I sent it. I didn't really mean it. Um, and then, you look around, you talk to some other people, and it makes a lot of sense. But by the same token, you don't take that and say, well, all victims of sexual assault say these things. In fact, most of them even, interact sexually with the person later, go out and find somebody else to have sex with that same night. Those are myths. And so I don't think that they should just be accepted as typical behavior of a victim of sexual assault, or, something that, really is indicative of a behavior of a victim of sexual assault, nor should it be discounted totally. And so I think that one thing you've taught me in these trainings is you have a piece of evidence, ask everybody for an explanation, but then you have to keep going. You have to keep looking into it, because gone are the days where experts come into court like they did, 20 years ago when I was first trying rape cases, or actually 30 years ago, where they come in and they say, oh, all of this behavior it means that this person was sexually assaulted. I mean, court cases have addressed that. You can't really do that, and nor should you. It's not fair to anybody who's participating in the process.
think? Follow the facts, and that's going to take us away from, because all this stuff about sex stereotyping and assumptions are things that are external to the case. That we're applying our own views, things that we've learned, things that we've believed or been taught since we were young, or we learned last week, but they're all things that are external to the case, so we have to try and focus on the facts. So I don't need to repeat that, that's here. Yeah, I'm just going to click through things that I think that we've already covered. Yeah, that's all there. Talked about that. We talked about the inherent conflict of interest piece. We've talked about that. Common sense approach to bias. Again, I'll only say about that again, when you're thinking about things you might do externally or things you volunteer for, or things that you're going to retweet or so on, be thoughtful if you are in a role as a neutral, as a Title IX coordinator, investigator, adjudicator, decision maker, what have you. Be thoughtful about how that will appear to someone who's on the different aspect. There's a polar aspect to what you're sending. How will that appear to them? First and foremost, how does that appear to them as a member of your community who's very vulnerable as a complainant or a respondent in one of these cases? How does that appear to them? Secondarily, how does it appear from a legal conflict perspective, knowing that everything can and will be dragged up from what you've sent out? So just need to be thoughtful about that. Focus on the facts. Don't be biased against anyone. That's pretty much the simple thing there. But it's hard to do in practice, but it's easy to say. But we can actually strive toward that for sure. Yeah, this stuff is, this is about your investigators. They've got certain things they have to do about directly related evidence. I don't want to spend undue time on that. It's a relatively broader term than relevance. It's really, they have to gather up virtually everything that they find, provide it to the parties, so the parties can make an argument about whether they think it's relevant. And there may be things in there like victim blaming statements, or, this person is we all know that they act like a rapist or something like that, or I think they've done bad things to other people. We don't think it's relevant because it's not about our case. We know better than that. Your witnesses are going to blurt stuff out, and probably have to provide all of that to the parties so they can argue about it. But that doesn't mean we have to factor it into our investigation. Margie.
Jeff, a question came up for us when we were thinking about this directly related evidence that we're not going to use in our investigations. And I've talked to some colleagues about this too, and they're just curious, when you're handing over this pile of directly related evidence, but evidence that you're not necessarily going to use, the question came up is, should we be redacting that? Suppose, for example, Jeff, that, it's directly related because this person, this person, this person all think that the respondent is, has a predisposition to, commit these kinds of acts, or, and the names are in there, and there's some pretty awful things. You're not using that in your investigation. But what I'm asking you is, do you think that all of us should be careful and redacting that kind of information, or at least the names of the people that say it, or do you think it just goes?
So I think, the easiest part of the answer is if something is privileged, right? So the regs specifically say that it's privileged. So if you have, and someone hasn't waived the privilege. So let's say somebody wants to submit a SANE exam report, or they want to submit a police report that has statements in it that they think corroborate their account, complainant or respondent. Police report's not going to be privileged. The SANE exam is. Somebody wants to put in their counseling records, but they want to do it on a selective basis. If there are pieces of the SANE exam that are directly related because they talk about the alleged assault, then that's something that I think is directly related. They've entered it into the record. There may be other parts of the record that talks about their medical history that have absolutely nothing to do with it, and I'd be happy to defend redacting those things. And the department in the preamble does talk about redacting things. What you've given for a hypothetical is considerably more difficult. I guess what I would probably do with that, if you've got those kinds of statements, your complainant is going to think, well, commonsensically, if they're doing it to others, then it's more likely that it's going to be established that they did it to me. I know they did from my experience. So I want that information so I can argue about how relevant it is. I'm probably redacting the names of people who are other reported victims of sexual assault, because I don't think that those people have opened themselves up for this. They did not volunteer to be part of this. They've not been part of a full process, or if they have, it hasn't gotten there yet. So I'm probably redacting their names. I'm probably not redacting who said it, and that's probably how I would approach it. But I don't think we redact it wholesale because, it's again, I don't look at it as being particularly relevant. Sophisticated investigators don't either. Common sense might say it, but it doesn't prove a particular case. Nonetheless, I probably would leave it in there. names of people that are things that are super sensitive like that. Okay. So relevance, we got to teach about relevance. It's extremely broad. Your hearing folks have got to understand their role, know that they have a lot of discretion, and then the basic thrust should be they've got to know that they have the ability to control the hearing environment, that they have the ability to maintain decorum there. They're going to follow your policies, but the policies vest a lot of discretion in the institutions as to what they can do, which is something that they have to understand because you're going to be your representatives. What they do in that hearing is going to be what both parties feel in terms of fairness, particularly because if they're the chair and they're making the decision, or if they're chairing and others are making the decision, they're at the hearing. However it works, the activities of the chair are going to be highly scrutinized by the parties because, well, it may be one of many hearings that they do. Hopefully, it's the only event like that that the parties have ever been involved in. They're hyper focused on it. So those folks have to understand the authority they have, the obligation they have to represent the institution in a very high stakes manner. Okay? They're going to have to control advisors. Got rules around that. We can have detailed rules of decorum should we want to. So that's something that schools are developing. Sometimes they're going to get their policies done by Friday, and I'm certainly working with a lot of schools that are saying, okay, now we're going to do our rules of decorum as we've talked about in policies. So that is to be established over the next couple of weeks. But in terms of cross-examination, the rules are there. We can talk about that. One thing that I've done with hearing officers and will continue to is you have people who are experienced as attorneys who work in a courtroom setting and are used to that setting, and they're used to the rules of just relevance, but the whole rules of evidence, which are much broader and more nuanced. But they're also used to a process where the questions are asked, and unless there's an objection, an answer is expected. And there's a different process for Title IX hearings where the question is posed, the chair nods, says, go ahead, or you don't have to answer that, it's not relevant. And that interrupts the flow. The department says it's intentional to slow things down. Obviously, people trying to develop a rhythm to get into a cross-examination are going to try and counteract that. We'll have to see how it plays out, but it's going to take chairs who are a bit practiced in a role that's different for them. So some of the things I've done working on hearing officer training is role playing, saying, okay, here we are, we're in the hearing. I played the role of a complainant who was, assaulted by someone that I was in a hypothetical relationship with, and the people involved, I'll be cross-examined, and then the other person gets cross-examined, and the hearing officer has to react in real time to intentionally obnoxious questions, right? And how do we nuance the curbing of obnoxiousness in a system that only allows us to object on the basis of relevance? And that's not easy to do. It can be done, but it's not easy to do. So that's something that we practice. So that was one strategy around how to do that. We have to talk about the technology to be used. The department says so. Hopefully someone is there who knows how to run it, because we certainly don't want that getting in the way, but we have to talk about that. We have to talk about prior sexual behavior related issues and privilege issues, as we've talked about. Those are relatively easy to understand. Probably the less easy nuance to understand is the piece around prior sexual behavior between parties that is used to demonstrate consent. So that's something that we probably should have a nuanced discussion around with our hearing officers so they understand this is not relevant, or it is relevant depending on what it's being used for. Certainly never being used to suggest that someone consented on this occasion just because they consented on another occasion, because we have to have consent to act on every occasion. However, parties will say, I assumed I had consent because we had done this on prior occasions and it was very much consensual. And then it's for typically the complainant to say, no, this occasion was different and this is why. And so those are the kinds of information exchanges that we're going to have. And these evidentiary issues are going to play into that. I know we've lost Margie, so we'll wait for Margie to log back in, and it's why I'm talking instead of I would rather listen to Margie talk than myself. So again, we've talked a bit about these issues and ensuring the trauma-informed approach. the language is in here, the department responding to critics and skeptics to say, um, we can rely on these approaches. We can do it in a nuanced way. We can train people. And if you want to see examples of the kinds of things you want your trainers to be thoughtful of, look at the white paper. There's a last section that says we can use gender neutral examples. We can emphasize procedural awareness. We can talk about why we're using a trauma informed approach. And it's not because we believe people because they appear to be traumatized and stop our investigation then, but we also don't want to be judging and victim blaming and saying, well, we're not going to listen further if they don't act the way we think a typical victim should act. All of those stereotypes should be set aside so that we're doing an independent, fair, and objective investigation based on the facts, not any of the prejudgments. So the paper talks about some of the things you can use as examples to do that. And fortunately, the department, well, was very much emphasizing fair process in its view, what constitutes fair process, which all do not agree with, is necessary at their level. You're going to be well within it if you're emphasizing the need to be fair and balanced in what you're doing along the lines of what we say in the paper. We're questioning for clarification. We're doing that with respondents as well as complainants. Margie gave you some examples of trauma-informed questions around tell me more about things, help me understand your thoughts about things. Those are things that we can do with respondents absolutely as well as we can do with complainants. And we can train people to do that. And certainly I've spent a lot of time doing that, and I've learned to do it as well. So with that, I want to leave time for training with the campus community. Margie logs back in. I want to hear her thoughts on that. I'll just say, please, I have a question mark around advisors. People are asking, I know we have to provide advisors for the purpose of providing cross-examination for conducting it. Do we have to train them? The department says no, they don't have to be trained. They don't have to have particular training or qualifications. They basically have to be a person whose voice can be used in lieu of the voice of the party to ask questions that the party wants asked. Got to go continuum from that to a highly trained trial lawyer who is focused on conducting cross-examination. They're paid by the party. So there's this huge range. All of it is fine from the department's perspective, and they don't say schools have to do anything different. I definitely have clients who are relatively higher developed programs, larger institutions, who are saying our advisors can be better able to participate in our program if they have some training, not on how to do a killer cross, because you're not going to do that in the time period we want to allow, but more how do we approach the issues? What are our hearings going to be like? What are our decorum rules? That sort of thing. What are your obligations as an advisor in this unique system? So those are the kind of things that we would cover there. All right. So we are a couple minutes off. Leaves time to first just say thank you so much to all of you who've been with us. These many great presentations. I know it's a tough week. For those of you listening to this after the fact, that know that this is available. We hope that it's helpful. I thank Margie if she swings back in the last minute. She said a thunderstorm was coming in New York, so hopefully she swings back in. But if not, Margie opened these sessions with me and another colleague and has now closed them. And I really want to thank the people at CDE. Just done a terrific job making sure that all of the great presentations from the folks that we've been able to recruit to help us and help you all over the last weeks have been able to get their voices and thoughts across. Our dear colleague Tom Mercurio is one of our most stalwart moderators, and we so appreciate his role as well. I'm going to stop talking for a moment and turn it back over to Tom.
Jeff, our thanks to you as well on behalf of the division here and the Board of Advisors of the Legal Issues Conference. We're very grateful for you and Marjorie and for your participation. And as it says in the PowerPoint, we hope you'll join us this fall online for the 30th Annual Legal Issues in Higher Education Conference, October 19th to 21st. Thanks to everyone here at UVM who makes this series possible, and a recording of this session will be sent out to everyone who registered, along with an evaluation to complete about today's webinar. Thanks. Bye-bye now.
Thank you. Thanks, Margie.
Yep.